Professor Hayashi, if you want to start, you can have the floor, and if you want any help concerning your PowerPoint, don't hesitate to ask us.
Merci beaucoup. Thank you very much. Bonjour tout le monde. My name is Hayashi Yoko. I'm a practicing attorney in Tokyo. First of all, to express my respect to the organizer of this summer school, let me give you a few words in my very bad French. C'est un grand honneur et grand plaisir pour moi d'avoir l'occasion de donner une conférence au cours de l'été 2021 de l'Institut des droits de l'homme. J'aimerais d'abord exprimer toute ma gratitude à la Fondation René Cassin et la Fondation du Japon qui m'ont invité à cet événement. Je suis en outre particulièrement ravi d'avoir eu cette opportunité à l'occasion du 25e anniversaire de l'accession au statut d'observateur du Japon au Conseil de l'Europe. Je vous remercie vivement et s'il vous plaît, permettez-moi de m'exprimer en anglais à partir de maintenant. Vos commentaires et questions seront les bienvenus. So I'll talk about 30 minutes and the remaining 15 minutes will be open for questions. So let me share with you my PowerPoint slide. Can you see?
Okay. Yes, everything is fine.
Okay. So I was a member and the chairperson of the Committee on the Elimination of Discrimination Against Women, CEDAW. This photo was taken in New York at the chairperson's meeting in 2016. From the third from the left, we can see Professor Emmanuel Decaux, then the president of the chairperson's meeting. So I enjoyed working with him very much. Therefore, this time I'm very pleased to be invited to this institute. The CEDAW Convention, adopted in 1979 in the United Nations General Assembly, is said to be the most significant product of the United Nations Decade for Women. It holds a special status as an international document on the gender equality because of its comprehensive scope and legally binding force with universal jurisdiction. At present, there are 189 state parties of the convention, among which 114 ratified or acceded its optional protocol. The United States is one of the very few countries which have not ratified the CEDAW Convention. The CEDAW Committee made an unofficial visit to the State Department of USA under the Obama administration in 2009. The American Society of International Law sponsored a visit to Washington, D.C. From New York. So this photo was taken in the headquarters of ASIL in D.C. A part of international law on human rights, the CEDAW Convention is a living instrument, which must be interpreted in light of present-day conditions and in accordance with the developments in international law, so as to reflect the increasingly high standards required in the area of human rights protection. I have identified 3 points that most significantly exemplify the evolution of the CEDAW Convention during the almost 40 years since its inception. Firstly, the obligation of the state parties became more clearly articulated in various work products of the CEDAW Committee, a treaty body which monitors the implementation of the convention. These products include general recommendation or general comments. CEDAW uses the general recommendation, but the other treaty bodies, it's more usual to describe general comments. Concluding observations, which is adopted after the constructive dialogue with state parties, and decisions views under the optional protocol. For example, the concepts such as direct and indirect discrimination, obligation to promote, protect, and ensure are defined in general recommendations and applied to cases of individual complaints. The secondary, the recognition of intersectionality, as well as the rejection of traditional understandings of gender as binary, has been enhanced. The committee has received increased number of complaints from minority women, refugee women, migrant women, women with disabilities, LGBTI women, to name a few. Each one of them have submitted their particular form of discrimination through which the CEDAW committee has recognized the necessity of laws and policies effectively responding to these diversified forms of discrimination. Thirdly, the new forms of violation of human rights against women have risen. Armed conflict, terrorism, disaster, climate change, cyberspace crimes, and abuses by transnational corporations. Not all of them are man-made. However, the committee has endeavored to confront these challenges as forms of discrimination against women. One of the outcomes of these efforts is guidance note on COVID-19 issued by the CEDAW committee in March this year. This document draws attention to the disproportionate impact of the pandemic, including the issues of sexual and reproductive health services, gender-based violence, and socio-economic support to women. The committee calls on the state parties to strengthen institutional response, dissemination of information, and data collection. I hope this guidance note has been and will be widely used by a variety of stakeholders and all over the world. One thing that cannot be stressed more is that the importance of collaboration between the treaty bodies and the academia. When CEDAW updated its general recommendation on gender-based violence, Center for Women, Peace and Security of London School of Economics and Political Science, headed by Professor Christine Tsinkin, they generously sponsored a few-day workshop at LSE. The CEDAW benefited from invaluable comments from academicians and activists and civil society, including Professor Tsinkin and Professor Andrew Clapham. Also, the work of civil society and women's organizations is indispensable. This photo was taken in Tokyo in 2012 when Madame Michelle Bachelet visited Japan as executive director of UN Women. As you know, now she serves as the UN High Commissioner of Human Rights. From during my 11-year term as a member of the CEDAW committee, I can recall the two most extraordinary memorable moments. One was when CEDAW was informed that European Court of Human Rights for the first time cited the case law of CEDAW. It was about Ops versus Turkey of 2009. This is the groundbreaking decision which expanded the scope of international human rights law for victims of domestic violence. One may not imagine the degree of enthusiasm and elation expressed by the members of the working group on the optional protocol of CEDAW. The Ops versus Turkey judgment was built upon two remarkable individual complaint cases of CEDAW, namely AT versus, sorry, I exhibited the wrong slide. the Offspring versus Turkey was built upon the two famous remarkable individual complaint cases of CEDAW, namely AT versus Hungary and Yedlin versus Austria. The judgment stated, in interpreting the provisions of the convention and the scope of the state obligations, the court will also look for any consensus and common values emerging from the practice of European states and specialized international instruments such as CEDAW, as well as giving heed to the evolution of norms and principles in international law through other developments. The court found that domestic violence affected mainly women, while the general and discriminatory judicial passivity in Turkey created a climate that was conducive to it. Therefore, the violence suffered by the applicant and her mother could be regarded as gender-based discrimination against women under Article 14 of the European Convention. Another moment which was engraved in the history of CEDAW is about the Spanish Supreme Court decision on Angela González Carreno versus Spain in 2018, in which the Spanish court endorsed that the CEDAW committee's decision was legally binding, and the court ordered the government of Spain to pay 600,000 euros as compensation for damages to the applicant whose claim was upheld by the CEDAW committee. So I couldn't trace if or not the Spanish government actually paid this compensation to the victims. So if any participants know about the aftermath of this Gonzalez case, so I would be most grateful to listen to that. I feel immensely fortunate to have been able to witness these moments that evince the evolvement of CEDAW Convention on site, its incorporation in the European Court of Human Rights, and its strengthening of enforcement at domestic court. So having described the development of the CEDAW, I would like to turn to the situation in Japan. Japan has adopted monastic system under its constitutional regime, which does not require particular domestic legislation to effectuate ratified treaties. However, the judiciary interprets that only self-executing treaties can be invoked in the domestic court. For example, in Japan, married women's right to maintain separate surnames from their husbands is one of the key issues in the gender equality agenda. The civil code provides that married couple must adopt one unified surname chosen by the couple upon marriage, which in practice deprives women of her surname upon marriage. In reality, more than 96% couples choose husband surnames. A group of married couples whose marriage legislation was rejected by the municipalities because they did not specify a chosen surname, filed a joint lawsuit against the government by invoking the CEDAW Convention in addition to the equality principle in the convention. So as you quoted in the slide, Article 16 of the convention provides the states parties shall take all appropriate measures to eliminate discrimination against women in all matters relating to marriage and family relations, and in particular shall ensure on the basis of equality of men and women. And Article 116(1)(g) provides that the same personal rights as husband and wife, including the right to choose a family name, a profession, and an occupation. Last month, the Grand Bench of the Supreme Court of Japan upheld the Tokyo High Court decision, which dismissed their complaints. The reasoning of the High Court is that in order for international treaties to be directly applicable and be served as a source of judgment, there are two requirements, namely subjective and objective tests. According to the judgment, the state parties must intend that the treaty in question provides rights and obligations of individuals, and the provisions of the treaties are unequivocal and sufficient enough to the extent that they do not necessitate any supplementary laws and regulations to materialize the rights. The High Court stated that the provision of the CEDAW Convention were not drafted in a manner that directly grants rights to individuals. Rather, the Convention declares that the state parties have undertaken political responsibilities to progressively promote the realization of the rights enshrined in the Convention. The court interpreted that provision of Article 61G of the Convention were not unequivocal, nor were they vested with necessary organs or procedures to execute rights. Therefore, the court ruled that the Convention cannot be invoked as a basis of the law. So among 15 justices of the Supreme Court, 3 members submitted dissenting opinions against the ruling. They argue that Article 16(1)G of the Convention is unequivocal enough and legally binding. Of course, I support this minority view. They submit that negligence of the Parliament can be deemed unconstitutional because they have ignored repeated recommendations from the CEDAW Committee as the outcome of the constructive dialogue with the Japanese government since 2003 to amend the civil code in compliance with the Article 16 of the Convention. Within the legal profession in Japan, unfortunately, the knowledge of international law has not been sufficiently disseminated. I hope that the eventual ratification of individual complaint procedures, none of which has not been ratified by Japan yet, will advance the knowledge and expertise of international law. Now let me pick up one of the emerging issues to the human rights agenda in Japan, that is business and human rights, particularly the supply chain problem. Japan is ranked as the 3rd biggest economic power in the world after US and China. Also, the country is the 4th biggest donor of the overseas development aids after US, Germany, and UK. Therefore, the conduct of Japanese enterprises, both domestic or transnational, have substantial impact for the rest of the world, particularly the developing countries. Traditionally, scholars and practitioners argue whether or not non-state actors may have a legal personality under international law as a rights holder. The question for today is whether or not non-state actors can be responsible for their conduct under international law in cases of human rights violations. Nikkei, a Japanese newspaper, recently conducted a survey of 100 CEOs of Japanese corporations about the risk of their business arising from human rights violations. Nearly 80% respondents answered they had seen the increase of such risk. Regarding the potential for risks, they responded that there are difficulties in controlling supply chains. So this photo is the Shelbourne Summit in Canada in 2018. This year, Canada was the president of the Group 7, and they started the Gender Equality Advisory Council within the mechanism of the G7. And the agendas of gender equality or the inequality or the business and human rights. And these are emerging from the G7 meeting as well. This year, the United Kingdom was the president of the G7, and in their communique in the G7 summit, they incorporated the necessity to strengthen the cooperation and collective efforts towards eradication, the use of all forms of forced labor in global supply chains. Last week, it was reported that the French prosecutors opened an investigation into 4 multinational fashion retailers on suspicion of concealing and profiting from crimes against humanity in China's Xinjiang region by sourcing goods produced by forced Uyghur labor. Among the 4 companies included Uniqlo, France, owned by the Fast Retailing based in Japan, and Inditex, which owns Zara. The companies denied the allegations, but responded they would cooperate with the French investigation. This incident is a good example of the emergence of new challenges of business. The United Nations adopted the guiding principle of business and human rights in 2011. It urges many states, including Japan, to adopt the National Action Plan on Business and Human Rights, and Japan finally did it last year in October 2020. Prior to this adoption, there were multiple efforts, including the ILO's Declaration of Principles Concerning Multinational Enterprises, the UN Global Compact, UN Guiding Principles of Business and Human Rights, which is mentioned, OECD Due Diligence Guidelines for Responsible Business Conduct, to name a few. The UN Working Group on Business and Human Rights recently launched the guidance note on the role of the United Nations guiding principles. Such moves are all welcomed, but the National Action Plan should accompany concrete targets and allocate responsibilities across actors, pursue meaningful stakeholder engagement by supporting access to remedies and legitimate mediation mechanisms, including corporate level grievance procedures. These are all critical components of supply chain due diligence. And I would say Japan's National Action Plan is still lenient or weak to cover all the points that I raised. Professor Andrew Krapfman of the Graduate Institute of International Studies in Geneva wrote in 2006, the paradigm shift is coming as business are treated not only as partners, but as having responsibilities under the international law of human rights. This point is nearer than is usually imagined. In fact, many of us imagine we are already there. That was written 15 years ago. Therefore, we have come to a certain point to assess the responsibility of these transnationals or non-state actors. So we all live in a dynamic era of transforming societies. International human rights law alone cannot be the magic stick that fixes all of the world's challenges, but it can serve as a powerful catalyst for positive systemic changes where the people will exist. I congratulate all of the participants of this summer course and commend your intellectual curiosity in those who are disadvantaged. I wish you all the best for your future endeavors and look forward to seeing some of you in person eventually when our paths cross with each other. Thank you very much. Merci beaucoup. So now the floor is open to the questions. So how I can see the chat? Excuse me. Okay. Excuse me. Excuse me, I cannot see the chat. Moment.
You could stop the screen sharing.
Yeah.
On top of the computer, and then you can see all of us and also the chat.
Yeah. Okay.
Dear Professor Hayashi, everything is okay?
Yes, it's okay. So I'm reading now.
Okay, great.
Okay. CEDAW, so the first question, thank you for the questions. The first one is from the Lucas Mendes. CEDAW works within the logic of an international human law. Would you consider that there is a Japanese approach to international law? If so, how this affects the country's internationalization of human rights? Well, if I understand your question correctly, I did not intend that there is a specific or special Japanese approach or a particular approach to international law. So I support the universal standards and the universal jurisdiction of the CEDAW Convention. Therefore, I'm very critical about how the Japanese judiciary interprets the CEDAW Convention or the international human rights law in general. Therefore, as a human rights lawyer, which I identify myself, we are combating actually this sort of the interpretation of the very narrow interpretation, only those international treaties, which those the subjective and the objective are the appropriate for the self-execution. Our court adopted this kind of approach, but Japan should, for example, ratify the optional protocol or individual complaint mechanisms, so that we can have more better understanding of the universal value of the human rights treaties. Is that? So can I understand this is the only questions from the floor? If so,
I suppose so, Professor Hayashi.
Okay, thank you. So if there if a person who raised this question, Lucas Mendes, do you have any comments, or do you have any further comments on this point? That you for the answer. Okay. Okay. Oh, it's shame that he can't open the microphone. Oh la la. Are there any other questions? For your background information, Japan ratified the 9 of the UN core human rights documents. The only remaining one is the Convention on the Migrant Workers and their Families Protection. But I understand that the number of state parties of that particular convention is relatively smaller than other 8. The problem is, as I said, that none of the Japan has not ratified none of the optional protocol procedure. Now all of these 9 core UN treaties, they have the individual complaint mechanism, and in case of CEDAW, not only the individual complaints, but also the inquiry procedure. The Fendi committee found the systematic violation of the human rights. The committee can invest the situation and can issue views on the particular facts. I read the program of your summer school, and it's so comprehensive, and it covers not only UN, but also Europeans, the Latin American, and the African human rights system. And I heard that many of you are the professionals and they have the postgraduate degree. And I really envy you that you have this kind of opportunity to learn, and if you go back to your home or your region, so you can disseminate what you can motivate people to build up a better world. So thank you for your question. Did you have any difficulty when you were working in the CEDAW or in any other forum, for example, because of a difference of attitude towards human rights between Japan and the rest of the world? Yes, I was brought up in Japan, though I studied briefly in Europe, UK, but my mind purely and set up. My mindset is purely Japanese. Therefore, I myself thought that I'm a feminist. I'm a very strong feminist fighting against the inequality. But when I was in CEDAW, they say, Yoko, why you are always treating so kindly to state parties? We should criticize, or we should look at this point. This is very new for me. And sometimes they say, Yoko, you are a well-balanced person. At first, I was commended by them, but at least in my understanding in CEDAW, the well-balanced is not the commending, but sometimes it's very critical. So personally, of course, it's difficult. But for me, the Japanese legal profession is a very male-dominant society. Therefore, it is more difficult for me to work in the environment in Japan rather than working in CEDAW. But it was anyway a good experience for me to be exposed in the human rights treaty bodies for 3 terms. And now term is over, and now I think it's a time for me to nurture, the advance, and implant my knowledge from UN system to my own country, and to share and to build upon new activities and the new frontiers. Thank you. The question from the Mr. David Alexandre Bosse. To what extent would you say that Japan's culture or the mentality has impacted the interpretation of the gender equality rights by the domestic Japanese judiciary? Thank you for all these good questions. Where of course, if I'm asked to what extent, my answer is nearly 100%, because there are very few, I would say, Japanese judges who actually studied overseas. One of the reasons is the bar exam is too tough, and the law school students must concentrate on just the examination for years and years to pass. And therefore, it's difficult to take a leave for 1 year or 2 years at overseas countries. Therefore, our culture on mentality has impacted the interpretation of the gender equality. That is one hand. That on the other hand, the new generation of lawyers, or and the people who have learned about the international human rights law, they are attempting to change or to transform these interpretations. Such challenge can take a form of the litigation, or the academic articles, or some forms of contribution can be possible. But the changes are ongoing. That is my answer. Thank you again, the questions from Lucas Mendes. Besides the criteria on direct effect rules on treaties, what other difficulties are developed by Japanese courts to apply international law? A good question. The direct applicability is also, and this is could seem as a minor issue, but sometimes it's a big issue. Is that as Japanese is not the official language of the UN, none of the human rights treaties or conventions are written in Japanese. So we have to interpret either French or the Spanish or English, of course, mostly in English. For example, in Japanese, there's no particular good translation of the word to ensure. What do you mean by ensure? So as I introduced, one of the difference of the Supreme Court grant bench decision between the majority ruling and the minority ruling is how to understand the shall ensure in English. And the minority opinion, they interpreted that I think it's their interpretation is more authentic or nearer to the authoritative interpretation of the convention. But this is a language issue, and also, of course, the culture and the and this is not only Japan, but also I can see in some countries, there's some lawyers, especially judges, believe that our law is better than others of the world, And when I talked to the United States, the lawyers to ratification of the CEDAW Convention, they say that CEDAW, even the Afghanistan or the China and they are state parties of the convention, but the US has much better law than CEDAW, therefore we don't need it. And this kind of the discourse, sometimes I heard in the judicial formula in Japan, and they say that we have the constitution which have the equality principle under Article 14 of the Constitution, therefore no need to defer to ICCPR or the CEDAW or CRC because we have the principle, everything packed in the convention, but it is not true. The international human rights law, they are giving a certain level of they are requiring us a certain level of achievement, and actually we have to ensure it. I think I didn't realize the one question was raised by Chihiro-san. Okay, but I think I have answered all the questions in chat. So if not, can Chihiro-san or the staff members of the foundation, could you let me know?
Professor Hayashi, I think you have answered all the questions raised.
Yes. Thank you very much. And so now I think I have to close this lecture because I heard that you're going to have the next lecture at 2 o'clock sharply. Yes. Thank you very much for your active participation.
Thank you very much, Professor Hayashi, for this interesting lecture. I would like to thank you as well in the name of our director and the other members of the staff of the foundation. It was a great pleasure to collaborate with you again.
Merci beaucoup.
I would like just to inform our participants in order to not miss the following course of the Professor NAKANISHI this afternoon at 5 o'clock, I think, or 5:30, yes, at 5:30. for a course concerning the following topic: encounter between Japan and Europe and its consequences in the context of human rights. A course delivered by the professor Yumiko Nakanishi. Thank you again.
Thank you very much. Merci beaucoup. So, au revoir.
Au revoir.
Thank you.